In this lecture, we will discuss about Maternity Benefit Act 1961 and those amendments to Maternity Benefit Act in 2017. So, the very introduction relating to Maternity Benefit Act 1961 regulates the employment of women in factories, mines, the circus industry, plantations, and shops or establishments employing 10 or more persons, except the employer is who are covered under the Employee State Insurance Act 1948 for certain periods before and after childbirth and provide for maternity and other benefits. So the very act relates to the provisions relating to maternity benefit of the workplace are necessary to ensure job security, then protect necessary provisions relating to maternity benefit, and as such it would further benefit and useful before and after delivery of the child. All employers or organizations in India must give maternity leave to pregnant women. It is vital to ensure the overall well-being of the newborn child and the mother. So let us see the very benefits as provided under the different sections of the Act. So Section 4 of the Act provides prohibition on employment of women or for work by women during certain period, that is, the employer is prohibited from knowingly employing any women in any establishment during 6 weeks immediately following the day of or delivery, miscarriage, or medical termination of pregnancy. No women shall work in any establishment during the 6 weeks immediately following the day of her delivery, miscarriage, or medical termination of pregnancy without prejudice to the provisions of Section 6. No pregnant woman shall, on a request being made by her, be required by her employer to do any work of the following nature during the period of 1 month immediately preceding the period of 6 weeks before the date of her expected delivery and during the said period of 6 weeks for which the pregnant woman does not avail of the leave of absence as per the provisions under Section 6 in any work which is of hazardous nature or any work which involves long hours of standing or any work which in way is likely to interfere with her pregnancy or the normal development of the fetus or likely to cause a miscarriage or otherwise adversely affect her health. And as well, Section 5 provides right to payment for maternity benefit. So, it provides the right to payment for maternity benefit that every woman worker shall be entitled to maternity benefit and her employer shall be liable for payment of the rate of average daily wages for the period of her actual absence immediately preceding and intending the day of her delivery and of for 6 weeks immediately following such day. In this connection, paying the maternity benefit to a women worker shall mean the average daily wages payable to her for the days on which she worked during the period of 3 calendar months or 1 rupee a day, whichever is higher. Further, no woman shall be entitled to maternity benefit unless she has actually worked in an establishment or employment from whom she claims maternity benefit for a period of not less than 160 days. In the 12 preceding months, and as per the provisions of Section 5A of the Act, there must be continuance of work of the payment. So it provides for continuance of payment of maternity benefit in certain cases, and that is every woman shall be entitled to the payment of maternity benefit under the Act, notwithstanding the application of the Employees State Insurance Act 1948 to the factory or other establishment in which she is employed continue to be so entitled until she becomes qualified to claim maternity benefit under Section 50 of that Act, and as well Section 5B of the Act provides for payment of maternity benefit in certain cases, and as such, who is employed in a factory or other establishment with the provisions of the Employees State Insurance Act 1948 apply, or whose wages include remuneration for overtime work for a month exceed the amount specified in subclass or of clause 9 of section 2 of that act, and further who fulfills the conditions specified in subsection 2 of section 5 shall be entitled to the payment of maternity benefit under this act. As well, section 6, which provides certain restrictions on employment such as on any work which is of hazardous nature or any work which involves long hours of standing or any work which in way is likely to interfere with her pregnancy or the normal development of the fetus or health, so likely to cause her miscarriage or otherwise adversely affect her health. As well, Section 7 of the Act provides regarding maternity benefit in case of death. So, it provides for maternity benefit in case of death of a woman, that if a woman entitled to maternity benefit or any other amount under this act dies before receiving such maternity benefit under the second provision to section 5 subsection 3, the employer shall pay such benefit or amount to the person nominated by the women in the notice given under section 6, and in case there is no such nominee to her legal representative. So now we would like to discuss the very provisions relating to maternity benefit as in case of those which are falling under the amended clause and that is being added under the very provisions of section 11 of the act, and that section 11 relates to certain creches, and as such this is a kind of new development which was inserted under section 11A of the Act after the amendment of 2017 relating to creche facility. So, in the Principal Act, after section 11, following section, that is was inserted, and that was section 11A. Every establishment having 50 or more employees shall have the facility of creches within such distance as may be prescribed either separately or along with common facilities, provided that the employer shall allow 4 visits a day to the creche by the women, which shall also include the interval for not more than and to rest allowed to her. Every establishment shall intimate in writing and electronically to every woman at the time of her initial appointment regarding every benefit available under the Act. So, these are the important and relevant sections leading to Maternity Benefit Act 1961 and the very amendment of 2017, and now would like to discuss the very amendment of 2017. So, the 14th session of the Indian Labour Conference has recommended for enhancing maternity leave under Maternity Benefit Act 1961 from existing 12 weeks to 24 weeks. This recommendation has been reiterated during 45th and 46th session of the Indian Labour Conference. The Ministry of Women and Child Development and other stakeholders has also required to enhance maternity benefit under the Maternity Benefit Act 1961 based on the recommendation of the Indian Labour Conference and request from the various quarters and the deliberations during the tripartite consultations with stakeholders, it has been decided to amend the Maternity Benefit Act of 1961. So, the salient features of the Maternity Benefit Amendment Act of 2017 are as follows: as it increases the maximum period of maternity benefit from existing 12 weeks to 26 weeks in case of women who have less than 2 surviving children, and in other cases the existing period of 12 weeks maternity benefit shall continue. Further, another important salient feature is to extend the maternity benefits to a commissioning mother and adopting mother, and they shall be entitled to 12 weeks of maternity benefit from the date the child is handed over. Further, to facilitate work from home to a mother by inserting and enabling provisions and another salient feature to make it mandatory in respect of establishment having 50 or more employees to have the facility of creches either individually or as a shared common facility within such distance as may be prescribed by rules, and also to allow 4 visits to the creche by the women daily, including the interval for rest allowed to her. And further, every establishment shall intimate in writing and electronically to every woman at the time of her initial appointment about the benefits available under the Act. Further, the Act seeks to achieve the above object. So, now we would like to discuss in respect particularly the amendments and those salient features that we have discussed. So, the first one is relating to maternity leave duration. So, the very provision of the Act provide for a maternity leave of 12 weeks. This duration was increased in the Amendment Act of 2017 and all women are eligible to take a 26 maternity leave. They can take maternity leave from 8 weeks before the delivery date and take the rest 18 weeks after delivery. When a woman already has 2 children, the maternity leave is only of 12 weeks for the third and subsequent children. And the second important one is relating to commissioning and adopting mothers. So, maternity leave for commissioning and adopting mothers as under the Amendment Act of 2017 also grants 12 weeks of maternity leave to women who lawfully adopt a child below 3 months of age and a commissioning mother. A commissioning mother is a biological mother who uses her egg to make an embryo placed in another woman. The 12-week maternity leave will start from the day the child is given to the commissioning or adoptive mother. Then another salient features under the Amendment Act of 2017 is relating to work from home. So the 2017 amendment provides that an employer can allow a woman to work from home during pregnancy if the nature of work is such that it can be done from home. After the maternity leave period, the women can also use the option of working from home for a mutually agreed upon period between the company and the employee. And further, another important feature of the Amendment Act of 2017 relating to creche facilities. So, the Act provided that children or child care services should be available close by for all businesses with 50 or more employees. The employer must allow the mother to visit the child care facility 4 times in a day. This should cover our downtime. Also, further, we would like to discuss what exactly maternity leave means. So, maternity leave means The paid leave provided to a pregnant woman working in any organization. The Act provides the period of leave that an employer or organization must give to pregnant women before and after the delivery of their child, which is as follows. All pregnant women are eligible for 26 weeks of maternity leave for the first and second child, out of which they can take a maximum of 8 weeks leave before their expected delivery date. For the third and subsequent child, mothers are eligible for 12 weeks of maternity leave. A woman can take 6 week maternity leave in case of miscarriage or medical termination of pregnancy. However, she may have to produce proof of miscarriage and the leave period starts immediately following the miscarriage date. Further, all adopting or commissioning mothers can take up to 12 weeks of maternity leave starting from the day the newborn child is handed over to the mother. Additional leaves can be granted for new mothers requiring more recovery time. Employers can be punished with imprisonment if they contravene the provisions of the Act and do not provide maternity benefits for the mothers. And now we would discuss the very applicability of the law as amended under the 2017 amendment. So the Maternity Benefit Act applies to women working in public and private sector organizations. Thus, it applies to all women employed in private companies, government jobs, mines, plantations, factories, and organizations with 10 or more employees. However, the Maternity Benefit Act does not apply to women working in organizations with less than 10 employees and self-employed women. And now we would like to discuss the very rules of maternity leave. So, all those rules that we would like to discuss. The maternity leave policy and rules in India provide as such the employment or the employer must pay full salary to the women employees during her maternity leave period. The salary date is calculated according to her actual salary or daily wages in 3 months prior to her maternity leave request. Employer should not employ a woman during the 6 weeks immediately following her delivery or miscarriage. Employers must provide child care provisions and restore the woman to her previous position in the organization upon her return from the maternity leave period. Further, pregnant employees are entitled to the following workplace amenities such as hygienic restrooms, comfortable working and sitting arrangements, safe drinking water. Employers must not give pregnant women difficult tasks or long working hours 10 weeks before the expected delivery date to ensure the safety and health of the mother and child. Further, employers can grant additional leaves to mothers if they cannot return to work after the maternity leave period through a mutual agreement, and further employers can also grant work from home option to mothers through a mutual agreement between the employer and the mother. And now, another important aspect is leave for government employees as provided under the Amendment Act. So, as per the Maternity Benefit Act 1961 applies to state and central government employees, the job, the leave provisions and benefits provided under the Maternity Benefit Act 1961 apply to all women working in the government sector. Women government employees can take maternity leave for 26 weeks during pregnancy and delivery of the child. They can take leave 8 weeks prior to the delivery date and extended it up to 26 weeks after delivery. Even government employees adopting a child below 3 months or commissioning mothers can take 12 weeks of maternity leave after the child is handed over to the mother. And now we would like to discuss those maternity leave benefits, and in particularly such maternity leave benefits ensure the well-being of mothers and their children by providing time to recover and nurture their children. Any woman on maternity leave is entitled to receive the entire salary for the period of leave and medical benefits, thus providing or financial security. Employers cannot dismiss or fire women employees only due to pregnancy or when they are on maternity leave, thus providing job security during pregnancy. Maternity leave allows women to take time off or the delivery of their children while continuing their employment, which helps them to maintain their career progression. Maternity leave provides time for new mothers to recover from child birth and care for their health physically. Maternity leave rules give new mothers time to spend with their newborns, essential for holding all kind of attachment. And now we would like to discuss certain important landmark judgments. Those are provided under the Act, and as such these landmark judgments are B. Shah versus presiding officer, Labor Code 1978, and also Air India versus Nargis Mirza in 1981, then Neera Mathur versus Life Insurance Corporation of India. So also we would like to discuss other certain important judgments relating to maternity benefits as such. Rohini Balakrishna versus State of Kerala of 2018, and also the important leading case relating to Maternity Benefit Act is the Municipal Corporation of Delhi versus Female Workers Master Rule and others. 2000, then Hindustan Lever Employees Union versus Hindustan Lever Limited, which was decided in 1995. Then another important leading case, Misra Upadhyay versus State of Uttarakhand in 2024. So these are the very important cases related to Maternity Benefit Act 1961.